Welcome back, dear students. Today we are going to learn the drafting of an application for caveat under section 138 capital A of CPC. First of all, we must understand what is an application for caveat and what is the meaning of word caveat. Word caveat, in fact, is not defined in CPC, but according to dictionary meaning, a caveat is an entry made in the books of the offices of a registry or court to prevent a step being taken without previous notice to the person entering the caveat. So, dear students, caveat is a notice that certain actions may not be taken without informing the person who gave the notice. And caveat in Latin language means be aware. The section 148 capital A was added in CPC on the recommendation of 54th report of the Law Commission. In fact, caveat is a formal notice or warning given by an interested party to a court or public official or a judge that he should discontinue certain proceedings until caveator is given an opportunity to be heard. The person who lodges the caveat is known as caveator, and the total object of caveat, if you see, is the doctrine of audi alter partem. That is the basis of this caveat, which means here the other side also. Dear students, the object of section 148 capital A CPC affords an opportunity to a person of being heard before ex parte order is made, and secondly, it seeks to avoid multiplicity of proceedings. If you see the meaning of word caveat in Hindi language, word caveat means chetavani. A caveat remains valid for a period of 90 days from the date of its filing, unless the application, suit or revision is filed earlier. This section 148 capital A, as I told you, was added in CPC by CPC Amendment Act number 104 of 1976 with effect from 1st May 1977. My dear students, this caveat application is registered as a miscellaneous case. When the caveat gets exhausted or its purpose is achieved, this miscellaneous file gets merged into the main file. Truly speaking, section 148 capital A is a salutary provision. It allows a person to lodge a caveat in a suit or proceedings instituted or about to be instituted against him, and the section reads as under: where an application is expected to be made or has been made in a suit or proceedings or about to be instituted in a court, any person claiming a right to appear before the court on the hearing of such application may lodge a caveat in respect thereof. And clause 2, where a caveat has been lodged, the caveator shall serve a notice of the caveat by registered AD post on the person by whom the application has been or expected to be made. And clause 3, where after a caveat has been lodged, any application is filed in any suit or proceedings, the court shall serve a notice of the application on the caveator. And clause 4, where a notice of caveat has been served on the applicant, he shall forthwith furnish to the caveator at the caveator's expenses a copy of the application made by him, and also with copies of any paper or document which has been or may be filed by him in support of the application. And clause 5, where a caveat has been lodged, such caveat shall not remain forced after expiry of 90 days from the date on which it was lodged, unless a new caveat application is lodged before expiry of period of 90 days. So in nutshell, the total validity period of caveat application is 90 days. Now the question is, who may lodge a caveat? You see, the caveator must be a person claiming a right to appear before the court on hearing of the application, which the applicant might move for the grant of interim relief. Thus, a person who is totally stranger to the proceedings cannot lodge a caveat. And what is the format of caveat? No particular format of caveat is prescribed under CPC. A caveat may therefore be filed in the form of a petition or application, wherein the caveator has to specify the nature of the application which is expected to be made, and he has a right to appear before the court at the hearing of such application. Now, dear students, with this much background knowledge at the back of our mind, now we will start the drafting of an application for lodging a caveat. So first of all, as usual, you will have to select the name of the court. And in this illustration, the name of the court taken is in the High Court of Judicature at Allahabad, UP, caveat application number dash dash of 2017 in civil revision number dash dash of 2017. Now you will mention the judgment against which there is a possibility of revision or appeal being filed. So in the bracket, you will write down, arising out of the judgment and order dated 24th December 2016 in rent control case number 148 of 2014, styled as A versus X, passed by rent control and eviction officer, oblique district, additional district judge, Noida, Gautam Buddha Nagar. So these proceedings are likely to arise out of the judgment and order dated 24th December 2016. In the matter of X son of Y, resident of 906 Designers Park Sector 62, Noida, Gautam Buddha Nagar, UP. He is the petitioner, and versus A son of B, resident of 52 Lajpat Nagar, New Delhi, is the respondent, oblique caveator. So respondent is caveator here. Center heading will be caveat under section 148 capital A of CPC. And the opening sentence which you are supposed to draft, the salutary line will be, the caveator most respectfully submits as under. Para 1, that the Court of Rent Control and Eviction Officer, oblique Additional District and Sessions Judge Noida of District Gautam Buddha Nagar has passed eviction order against the petitioner X in RCC case number 148 of 2014, styled as A versus X on 24th December 2016 under section 21 of UP Urban Building Regulation of Letting, Rent and Eviction Act 1972. So eviction order has been passed against the petitioner X. Para 2, that the caveator A is expecting that petitioner X may file a civil revision petition against the said eviction order before this honorable court, and as such, this caveat is being lodged. Para 3, that the caveator has a right to appear and contest the civil revision if preferred by X. Para 4, that the caveator A desires that he may be given notice of filing of civil revision as and when it is filed by the petitioner X to enable him to appear at the time of hearing for admission of the civil revision. Para 5, that a copy of this caveat application has been sent to the petitioner X by registered AD post. And final prayer, it is therefore most respectfully prayed that nothing may be done in the said civil revision that may be filed by the petitioner without notice to the caveator or his counsel. And as usual, my dear students, the caveator A has to put his signatures on this application. And since this caveat application has been drafted by some advocate, you are supposed to write down the name of the advocate also, like through ABC advocate, and the signatures of ABC advocate are also required on this caveat application. Then you will write down the place where it was drafted. Place is Allahabad and date of filing is 1/1/2017. So you see the life of caveat I have calculated once again, that you are going to file this caveat application on 1st January 2017. So its life will continue up to 31st March 2017. That is equivalent to 90 days. So this care you must take, my dear students, while drafting an application for caveat, that it remains valid for 90 days only. So dear students, thank you very much.